neighbor girl who is already shown to be unreliable.
She's been proven to be reliable because she also says the neighbor's son, your defendant's son, assaulted her, and everybody seems to be in full and complete agreement that that has happened.
Welcome to Bench Report Court Cam.
Good afternoon. Good to see you, Your Honor.
Good seeing you.
Ellen Michaels, P67943, on behalf of James Worthington, who was present in court. Mr. Worthington, please state your name.
James Worthington.
Thank you. All right. What are we doing?
So today's date time set for probable cause conference. After talking with the prosecutor, it's clear that there is additional discovery that is still outstanding. And I am seeking your honor to sign a subpoena that I can send to your staff to subpoena documents from Michigan Department of Health and Human Services regarding CPS records, as well as the U of M hospital where the police transported my client's daughter to the hospital to be investigated. And she's not the complainant in this case. This was a follow-up to other allegations made by the complainant in this case.
The outstanding discovery that exists in the moment is for sure 2 CAC videos. There have been 3 children interviewed at the CAC. A charged victim was interviewed, and that has already been uploaded and disclosed and shared. 2 other children have since been interviewed. One of them is defendant's own minor child, daughter, and another one is a sister to the original complaining victim. The second one just happened this morning. I have emailed the deputy to request that those be uploaded ASAP so that they can be shared. As it pertains to medical records and the DHHS report, counsel did discuss that with me this afternoon prior to going on the record. I have also emailed the deputy requesting those records and reports. I leave to the discretion of the court if you prefer.
Well, if I don't have to,
it feels like it should be able to be discovered through law enforcement.
right, without the necessity of a subpoena. So I'm not going to issue a subpoena. I'm presuming if the prosecutor's office has asked, and if there becomes a hiccup in that, then I'll deal with it and I'll intervene. But usually that process runs pretty smooth in terms of getting the medical records and DHHS reports. So how much time do we need to try to accomplish all of that?
4 weeks.
Well, that would certainly do it. I would hope.
Okay.
I guess if we don't have everything, we can notify your staff and have a conversation about adjourning.
They'll tell you no.
I'm sorry?
Nothing. I just said they'll tell you no.
Yeah, right.
That's okay.
Good one.
All right. What I'll do is I'll adjourn it to January 23rd, 2025 at 9 a.m. or as your invite indicates.
I am not available that date. Can we?
Okay, I can do the 30th or I can do the 16th.
We could do the 16th, please.
All right, January 16th, 2025, 9 a.m. Bond continues.
Oh, and we do want to address bond.
Okay.
And I also discussed this with the prosecutor ahead of time. So currently there are bond conditions that my client cannot be around his 2 minor children, one of them being his daughter, Lila, who was 9 years old, the other one being his son, Leon, who was 13 years old. Lila was given a CSC interview as well as taken to the hospital. There are no charges filed with her. There were no allegations made against my client from his daughter. The allegations are from a 7-year-old neighbor girl. There's no prior history between them. I'm asking that the family be reunited. I know that the accuser is a neighbor. My client's family can stay with other friends, not in the same street where the complainant lives at this time, but I would like the family to be reunited. My client is innocent till proven guilty. CPS has cleared. There's no allegations. There's no involvement. There's no charges from my client to his children. He has no criminal history. I believe that in the interest of justice, the family should be reunited until my client is found guilty of anything.
Response from the people.
Thank you, Judge. I understand the ask. I certainly can't dispute that defendant's daughter, Lila, was interviewed and has not disclosed. Where I'm left is with the disclosures of her best good buddy, her neighbor child friend, who discloses not only that the defendant has assaulted her, so that's already a concern that we're focusing on a female child of the same age range, but also has disclosed that Lila disclosed to her that dad has done those things. So I am left in a place where I feel remiss agreeing to the amendment of any bond conditions that have anything to do with allowing the defendant exposure to and contact with the minor child. Again, I understand the ask. I'm not going to misspeak anybody. She has been interviewed and has not disclosed. But Judge, we all know that there are reasons why kids disclose and don't disclose, and I'm left with information that I think I have to act on and make recommendations.
May I respond?
You may.
Thank you. The Lila has denied that she was abused. She also has denied disclosing anything to this neighbor friend. She was taken to the hospital immediately, and there's no evidence of any abuse of any kind. And there's been no CPS report made or action taken for any professionals believing that any abuse is existing in this family. My client's wife is present in court. She, if asked by the court, could also speak to belief of the safety of the children and the way the family has been destroyed from just this allegation, from what we believe is the neighbor girl who is already shown to be unreliable by the investigation that's already been done, by alleging that my client's daughter said that he was abusing her, which has already been shown to be not true.
So that has absolutely not been shown to not be true. Just because one kid says a thing and another kid says a different thing doesn't mean that that is proof positive that the one kid is not being truthful. We all know that. We also know that when a child is taken to be medically evaluated and there is quote unquote no evidence of child assault, that also is not proof that no child assault occurred. I understand counsel's argument, but I for sure quibble with throwing our charged victim under the bus and referencing her as having been proven to be unreliable. In point of fact, she's been proven to be reliable because she also says the neighbor's son, your defendant's son, has assaulted her. And everybody seems to be in full and complete agreement that that has happened. So she's a truth teller
Hold on a
about
second.
that.
So that the 13-year-old?
Yes.
Okay, go ahead.
One more thing, Your Honor, that the allegations that Lila allegedly said to the neighbor were that my client penetrated her. If there was penetration, there certainly would have been medical evidence of penetration on a 9-year-old girl by a grown man. That's what I mean by uncorroborated allegations.
Just not an accurate recitation of reality. Just, it's not accurate.
All right, so are there, I guess, it's very odd. Let me start with the 13-year. Was it Leo?
Leon.
Leon. Are there juvenile anything coming as to him based upon what has occurred?
I believe that there will be. I believe that this investigation sort of began as one and has become dual and is ongoing.
Got it.
I can and will verify that, but I don't have that in front of me.
I can answer also is that Leon is autistic and has special needs. He is homeschooled, and his challenges are being addressed by the family.
Okay. I think at this point, given at least what I've heard, because there are some interviews that are ongoing, right? And there's some reports that have to still come out too. So what I'm going to do is I'm going to deny your request for a change in bond at this point in time. If additional information comes through or counsel wishes to raise it by written motion, certainly the court will take that up and allow a full-fledged answer to that. So, and so that you know, if you get one into us, giving adequate opportunity for the prosecutor to respond, we usually hear them, although you should probably contact my office at 3:00 on these Thursdays. Okay.
Thank you, Judge. As soon as I get any of those reports and if they support what I'm asking, I'll put together a motion.
All right. Very good. Okay.
Thank you very much.
Thank you.
Thank you.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.